Hello, my name is Fabian Degen. I'm the owner of FMD Wealth Advisors. This is my podcast, Don't Screw Up Divorce. I'm a certified financial planner, chartered financial analyst, enrolled agent with the IRS, certified divorce financial analyst, and certified quattro specialist. I help people that are going through major life transitions like divorce. I'm supporting my clients before, during, and after the divorce, and I work with clients nationwide. If you would like my help, click the link in the show description or visit fmdwealth.com to schedule a call with me. We are open for business. Before we get to this week's podcast, a very important disclaimer at this point. We are not attorneys and we do not provide legal advice. Anything that is being said should not be considered legal advice by any means. Please consult with your attorney with regard to your legal questions. So this week's topic is focusing on how to modify or extend an order of protection. An order of protection is not necessarily permanent or fixed. Depending on the circumstances, either party can ask the court to modify it, terminate it, or extended. These requests are usually made by filing an order to show cause along with an affidavit that justifies the change. The affidavit is where you lay out the factual basis for what you are asking the court to do. And it is the document the judge will scrutinize most closely. A vague affidavit rarely succeeds. A specific, well-supported one is far more persuasive. So can you modify a stay-away order? Yes. A stay-away order requires the respondent to physically stay away from the petitioner and from the petitioner's home, workplace, or school. That creates obvious logistical problems when the two people share a residence. To address this, a respondent can file a modification petition challenging the stay-away portion, or asking that it is being amended so they are not barred from their own home. Even where the respondent only needs to enter briefly to retrieve belongings, the right move is to ask the judge for permission to do so without violating the order, not to simply show up and risk arrest. So, asking first turns a potential violation into a sanctioned, supervised step. So another often used order is the usual terms order. The usual terms order bars the respondent from committing certain standard family offenses against the petitioner. When behavior escalates and circumstances change, a petitioner can file a modification petition to add stronger protections, such as a no-contact provision or stay-away provision. A petitioner can also ask the court to make a provision more specific. So suppose the original order contains a no-contact provision and the respondent simply started using a third party to relay messages instead. In that situation, the petitioner can file a modification petition asking the court to amend the order to bar third-party communications as well, closing the loophole. Let's talk if it's possible to extend an order before it expires. So New York law allows a petitioner to extend the length of an order of protection. If you have one order and you believe you need protection beyond that year, you can move to extend it. In most courts, you can do this through an order to show cause followed by an affidavit justifying the extension. An extension generally requires a factual basis amounting to good cause. So the court will hear your reasoning and review your evidence, and if it finds a sound basis, the judge might extend the order. Importantly, the fact that no new abuse occurred while the order was in place does not by itself defeat an extension. The absence of further incidents is not treated as proof that protection is no longer needed. So let's talk about what the court weighs in deciding. When deciding whether to modify an order, the court starts with the factual basis for the request. So consider a respondent who asks to remove a stay-away provision because it excludes them from their home. The judge is obliged to consider that argument and the evidence behind it, but will carefully assess whether the reasoning generally justifies the change. Courts are especially cautious before any trial has occurred because there's no track record of behavior or rulings to look back on. So the statute requires the judge to consider whether the order is likely to achieve its purpose without the disputed conditions. So in practice, once a judge has excluded someone from a specific area or activity, they are often hesitant to remove that restriction. A respondent can convincingly show they will literally be left on the street. Judges are normally very reluctant to lift a stay-away provision and will frequently suggest an expedited trial on the underlying family offense issue instead, prioritizing the safety of the victim. So let's talk about modifying an order of protection after finding of a family offense. So if the court has already found that the respondent committed a family offense, any later request to soften the order is examined through that lens. The judge looks closely at what, if anything, has actually changed since the order was entered. A respondent who has taken concrete steps can present their progress as a basis for modification. So, for example, completing counseling, or anger management classes, or finishing rehab and demonstrating sustained sobriety. The court then weighs whether those changes warrant adjusting the order. When it is the protected person who asks to relax their own order, the court takes a different way. It will make sure the request is generally the petitioner's own and not the product of duress or pressure. If a judge suspects the victim is being pressured, it may refer the matter to the district attorney's office or child protective services to keep everyone, including any child, safe. So, in that situation, let's talk about coordinating the practical and potential financial fallout of an order of protection. So, modifying or extending an order is rarely just a legal step. It ripples into living arrangements, who pays for what, and sometimes interim custody and support. A stay-away order can determine which spouse remains in the marital home, and an extension can affect housing and budgeting for another year or more. Because of that, it helps to treat modification or extensions as part of your broader plan rather than isolated court events. So, coordinating with a CDFA, Certified Divorce Financial Analyst, alongside your attorney lets you anticipate the practical consequences from duplicated housing costs to any interim support the order may carry. So a change to the order does not quietly undermine your financial footing. Let's talk about the conditions a court can set as a consequence of an order of protection. It definitely helps to know the range of conditions an order of protection can contain, because the range defines what you can ask the court to add, narrow, or remove. An order can direct a person to stay away from another party's home, school, business, or place of employment, to refrain from committing family offenses or from harassing, intimidating, or threatening the protected parties, and to permit court-ordered visitation at stated times. Other conditions can require a person to enter the residence only during a specific window, to remove personal belongings, to pay the reasonable counsel fees involved, to provide for medical expenses arising from the incident, and to promptly return identification documents such as passports or benefit cards. Because the menu is very broad, a modification request is most persuasive when it asks for a specific, well-defined change to a specific conditions rather than a vague loosening of the order as a whole. So let's talk why the court must articulate its reasons. So when a court issues, modifies, or extends an order of protection, it is required to articulate the basis for its decision on the record. And that requirement cuts both ways for you. The judge must engage with the factual basis you present, and your affidavit needs to give the court something concrete to rely on. The duration of any temporary order is not, by itself, a factor in deciding the length of a final order, and the fact that no abuse occurred while an order was in place does not automatically justify denying or refusing to extend it. Let's focus on some typical questions that I receive from my clients. How long can an order of protection last? A final order generally runs up to 2 years and up to 5 years where the court finds aggravating circumstances or that the conduct violated an existing order. So before expiration, a petitioner can move to extend the order for good cause, and the absence of new abuse during the order's term does not itself defeat an extension. So next question, can the protected person ask to drop or change the order? Yes, but the court will examine the request carefully. If a judge believes the protected person is acting under duress rather than freely, it can decline to modify and may involve the district attorney's office or child protection services to ensure ongoing safe. Next question, is family violence a basis to change custody or support? So domestic violence can be a material change of circumstances supporting a custody or visitation modification. It is usually not on its own a basis to change an earlier child or spousal support order, though it can be one factor among many in a broader support modification. For example, if an assault left someone unable to work. This was this week's podcast, Don't Screw Up Divorce. My name is Fabian Degen. I'm the owner of FMD Wealth Advisors. I'm a certified financial planner, chartered financial analyst, and enrolled agent with the IRS, certified divorce financial analyst, and certified quattro specialist. I help people that are going through major life transitions like divorce. I'm supporting my clients before, during, and after the divorce, and I work with clients nationwide. If you would like my help, click the link in the show description or visit fmdwealth.com to schedule a call with me. We are open for business.